Good day, everyone, and welcome to another edition of Q&A Social Security Disability Today. I am your host, Anthony Rees, and let's get going. Beforehand, I got to make sure I say a special blessings out to all those who are weathering the storm of Hurricane Andrew. If you have loved ones or family members or friends who are in the area, make sure you check in on them via text or phone call. If you're in that area, please, by all means, stay safe and hold out because help is going to definitely be on the way. All right, let's get down to today's questions. First question is, how do I deal with my doctor when they tell me one thing and then do something else? This question relates to a medical source statement, and more importantly, it relates to what happens when you're in your doctor's office. Kind of follow along me. You're in your doctor's office. You ask your doctor to write a letter on your behalf for the Social Security Administration. They say they do, and you ask them what they're going to put in it, and they tell you. And then all of a sudden, one of two things happens. One, they never do it. Or two, when they do it, it's not exactly what they told you it's going to be. So now you're in a situation where you're getting upset and you're trying to figure out, well, how do I deal with this situation where the doctor told me one thing and then did something totally different? Here's a couple of things that you need to be aware of, and I tell people this all the time. Doctors are professionals. If they take the time to write a statement out for you, that is a courtesy. In other words, that's a favor, meaning there's nothing that obligates them to have to do it for you, especially if they do it for free. Because a lot of times doctors will do those statements or fill out those forms, they're going to charge you for that. But if you've got a doctor that you've got a great relationship with, it is very possible that they'll write a form for you, fill out a form for you, or write a letter for you. Now, I always tell people, and I've written this in blogs before, that the reality is you don't know what they put in your notes. So you don't know what they're going to write down. So at the time when they're talking to you, the doctor may say, yeah, I'll write something. But then by the time they've gone back and checked their notes, what they may have said to you verbally might be different from the little shorthand notes they put in your chart. So I always tell people two things. First, before you start wilding out, getting mad because they didn't put the letter in there the way you want to, remember, they're doing you a favor. In other words, you're asking for their help. They don't have to do it. Second of all, if there is some confusion, just ask them politely. Hey, thank you very much for the letter. I noticed that we talked about some things I didn't see that was in the letter. Was I wrong or anything like that? I just want to make sure. I'm a firm believer that you catch more flies with honey than you do vinegar. So before you decide to start going off on a doctor who said they're going to fill out a form for you, remember, they're doing this as a favor. They don't have to do it. So keep that in the back of your mind. All right. Someone asked, when and how can I get a copy of my file, or excuse me, view a copy of my file? Okay. During the Social Security process, you probably already know that you can check for status at the very early phases, meaning if you're in a state that has two levels of denials, it's at the initial level or the recon level, you can check to see the status. If you're in a state with one level of denial, at the initial level, you can check the status. Once it goes to the hearing level, if your case is electronic, you should be able to get access to your file. Now, I'm going to tell you this, and I'm just going to be very blunt. I'm a representative. As a representative, I'm given the ability to view my clients' files. So I can see everything. I can see what's been submitted, what they have, what they don't have, forms, and everything. If you don't have anybody, I'll be very honest, I really don't know what to tell you. And the reason why is I'm not sure what the protocol Social Security utilizes in order to allow you to see your file in advance. Now, what may have to happen is you may have to ask them to give you a copy of a CD. Say, hey, can you send me a CD? And they can provide you a copy of your file that way. Representatives, we're a little different because the reason why they want us to be able to do it is so that we can upload records into your file, download things that we need. We're doing it for a little different purpose than if you're just trying to look to see what's going on. So what I would tell you to do is twofold. One, I would ask for a copy of a CD. Two, if your case is a paper file, ask for a time to go down there to copy your file. That's the best way to see what's going on, because I'm going to tell you, at the initial level, when you're either at initial or recon, or if you're just at the initial level, they're not going to let you see a copy of your file. I'm just telling you that right now. If you're at the initial levels, Where the local office is handling it, they're not going to let you see a copy of your file. Why? Well, because they're still developing your case. So they're trying to get all your information together. When it's at the hearing level, then you can get access to it. All right. Someone asked me, why would I need a representative payee? A representative payee, and I've talked about this before, is situations where Social Security is concerned that there is something going on in your case about you, and this is just being blunt, about you, that they're concerned that you may not be the best person to handle your funds. Well, where does this come up? Well, let's say you have a history of drugs and alcohol. Well, they don't want you to spend your money on drugs and alcohol, so they're going to let somebody else handle your money. Maybe you have some cognitive issues, like memory issues, maybe a low IQ, some indicators that maybe you are not the best person to handle your funds, so they may have somebody else do it. So in those instances, that's when they usually will require you to have a representative payee. Now, Social Security will typically give you the ability to demonstrate to them that you don't need one. And usually you do that through a doctor. So please don't say, well, I've been doing my bills for the longest, and I'm married, there's somebody in the house, what do I need a representative payee for? That has nothing to do with why they assign one to you. A lot of times it's because of a medical reason. And what you need to do is, when you think you don't need one, talk to Social Security, ask them to tell you what you need to provide to demonstrate that you don't need a representative payee. Now, have more of a philosophical question here, which I really like these, so keep them coming. What would be the next step for the American people to do if they have been forced into this involuntary system of paying for Social Security? If they get awarded, can they sue for the remainder of the money that they were forced to pay into? Now, this is what they basically are saying to me. You're getting disability benefits, but no one gave you the option to pay into Social Security. So, can you sue Social Security for the money they made you pay into the system? Here's where I tell people to be very careful. Think about the logic behind this. You're going to sue a program that awarded you benefits because they made you pay into the program that enabled you to get those benefits. You see kind of where I'm going here? It's almost like suing the state because you're required to have a driver's license. However, you can't get a car unless you have a driver's license. So you get the benefit of getting the car, but you want to sue the state for making you have a driver's license. The two just don't go together. You can't sue on one idea and try to get the benefit of the other. And I always remind people all the time, for those people who really raise Cain about Social Security money being taken out of their check, when I stop and I look at them, I say one thing: do you have a savings account? Well, no. You have a retirement account? Well, no. 401k? Well, no. Let me ask you this question: you have AFLAC? No. Long-term disability? No. Okay, so if you get hurt today, who are you planning on doing? Who are you planning on contacting? Well, Social Security. Now, if you haven't paid into the system, how do you expect to get that money? And then they look at you like crazy, and I'm like, I'm not trying to be funny. People fail to realize, and I'm going to jump to my question here when someone asks, how does the recent talk about Social Security running out of money affect those who are applying for Social Security now and in the future? Will less people get approved? Let me be blunt. The Social Security system has been a staple of our society for over 76 years. It was, in terms of Social Security itself. At the end of the day, if you have nothing, our country, in their wisdom, realize that this is the best way to ensure Americans have some safety net. People, this is your safety net if you have no retirement. It may not be a lot, but it's something, as opposed if you have nothing. If you get disabled, this is something if you don't have AFLAC or some long-term disability program that you're paying into, or some 401k. This is for your benefit. I've said this before, and I said it in a blog post on here not too long ago on my blog on legalbeat.anthonyreeves.com. I said it very nicely. Do I think Social Security is going away? Not really. Personally, I don't. Do I think that the version of Social Security that we have now will be in existence several years from now? Absolutely. I don't believe it's not. I don't believe it will be the same version. They are already making moves now, meaning they recently passed a ruling where if you're applying and you've gotten denied by a judge and then you want to reapply based on the same impairments that you got denied, you have to have a choice. You either file a new application and drop that old one, or you appeal that old one, but you can't do both. So they're already trying to work out ways to streamline the process. So do I think that the system will change? Absolutely. Do I think it's going anywhere? I don't think it's going anywhere anytime soon. But just keep in mind, This is one of those things where you need to be very active and be very vocal with your congressmen and your senators, because the system that you have today is going to be different than tomorrow. All right, see what other questions we got here. 2 questions. What's the likelihood that I'll get approved for Social Security for optic migraines, intractable migraines, and depression? You're not going to like this answer, and this is the one answer I tell people all the time. Can you get disability benefits for a variety of conditions, including this one? Yes, you can. What is the likelihood? I have no idea. Now, here's why I say that. It depends on what your medical records say. And sometimes what people will do is they'll send me messages and they'll send me this long breakdown of what their medical records, or at least their interpretation of the records, tells them. And invariably I tell people, listen, I've been doing this for almost 10 years. I got to see what your medical records say. Your medical records in their entirety will tell me whether your condition is one that will get you disability. One thing I try to tell people all the time is that there are few conditions out there that you are guaranteed to get disability just because you have it. Even cancer is not a guarantee depending on the type of cancer. So I always tell people all the time to be mindful of the fact, that at the end of the day, the important thing is that you're going to get treatment for your conditions. Don't focus so much on what the condition is. Focus on getting the treatment you need to prove that you're disabled. All right, final question. What are the appropriate steps to take with my insurance company who wants me to apply for Social Security while I'm getting long-term disability, and who want to represent me on my Social Security disability claim? I've told this to people in the past. When you're applying for long-term disability, it's not uncommon for the long-term disability carrier to require you to apply for Social Security, because what that does is it allows them the mechanism to be reimbursed for their monies that they pay you if it's determined that you're found disabled later. Long-term disability is an awesome asset for you because they can provide you forms, because they provide forms to the docs. They can take care of the medical records, and mind you, with the long-term, it really helps you have additional money coming in. So you have 2 and 3 things that are beneficial to you. Do you have to use their attorney? Not necessarily. You can always tell them that you don't want to use their attorney and you'd like to hire your own. But I always tell people this. The first thing you need to look at what the policy says, and then you need to make the determination of whether or not you want to use their resources. Here's the other thing I remind people with long-term disability, is that because their policies require you in some instances to reimburse them for any money you receive, read that policy carefully so you don't get freaked out through the disability process. All right, everyone, I want to thank you again for joining me for another edition of Q&A, Social Security Disability Today. I am your host, Anthony Reeves. Keep those questions coming, and I want you to all have a wonderful day. Take care.